All right, good afternoon. My name is Thomas Eineman. I'm a circuit judge in the 5th Judicial Circuit. I'm going to give you a very fast update in the area of domestic violence. I am going to go fast, but I got a lot of material to cover. First principle, and it's in the material Leapart v. James. And in that case, what had happened was the lady filed a petition for injunction. She claimed that her house had recently had shots fired at it, and also her car had been recently vandalized. She had no proof that the respondent had done any of those things. She claimed, however, that when the parties were dating a couple of years earlier, he had busted her lip during an argument. He denied that. In any event, the appellate court said even if he did bust her lip a couple of years ago before the filing of the petition, that is not going to be sufficient for the entry of a domestic violence injunction today, absent evidence that the respondent has committed current acts of domestic violence. A similar case in the material is the case of Zappiola and Kordecki, and in that case, the parties had been dating. The petition was filed in 2016. The petitioner alleged that back in 2012, when the parties were dating, the respondent threw a glass of wine on the petitioner and also punched the petitioner. Appellate court ultimately decided that that is simply insufficient now. What was the triggering event for the Zappiola petition was that the respondent had recently been attempting to contact the petitioner by Facebook and by email. No threats, importantly, were ever made in any of those Facebook attempts to reach the petitioner or phone calls. But in any event, an act of domestic violence that has occurred years before the filing of the petition is simply not going to be sufficient now. You can make the argument, though, that that really does not comply with the statute, because remember, under 740-130, for a domestic violence injunction, for the final injunction, the standard is, has the petitioner been the victim of domestic violence, or does he or she have a reasonable fear that domestic violence is imminent? These two cases, you could argue, don't really jive with that. Next I want to back up one more point. If you take a look in the material, there's a case called Battaglia versus Thompson, and that has some good generalized language about situations that I find come up a lot during these cases. And basically what the Battaglia court said is mental instability, bad temper, depressive and suicidal statements, angry messages, just general conditional future threats are simply not sufficient for the entry of a domestic violence injunction. Next, the case of Berrien versus State, which is kind of interesting. There was a final injunction entered. One of the parties filed a motion to dissolve that injunction. Judge conducted a hearing, ultimately entered an order dissolving the final injunction. However, a successor judge went ahead and began indirect criminal contempt proceedings against the respondent for failure to comply with the injunction and failure to attend a compliance hearing concerning the terms of the injunction. However, the successor judge had no authority to do that. Once the injunction was dissolved by the predecessor judge, it's over. That's it. The respondent did not need to comply with the injunction at that point. Next, of course, as you know, we are often called upon to address time sharing in these domestic violence injunctions. Case of Forzel versus Forzel basically says if the trial court enters an injunction and as part of that suspends the respondent's time sharing, the judge should go ahead and put in that order what does that respondent need to do to reinstate his time sharing. That's Forzel versus Forzel. Next, the case of Weiss versus Pettyhome. That basically stands for the proposition that although it may be tempting to do it, the trial court should not enter a series of temporary injunctions in lieu of a final injunction. If the parties consent, that's maybe different, but if you have the parties at a final hearing and one of the parties wants to plow ahead and have a final hearing, you really need to do it. And any temporary injunction needs to set a return hearing date. That's pretty obvious. Next, and this is the case of Thomas versus Biggers, and in this next point, we are not talking about third-party contact. As you all know, a typical provision in a domestic violence injunction is that the respondent is going to be ordered not to use other people to attempt to contact the petitioner. Tell her things like, I love you, I'm sorry, tell her I'll never do it again, that kind of thing. That's a standard prohibition. But in this case of Thomas versus Biggers, the trial court actually went ahead and entered an order that enjoined the respondent not only from contacting the petitioner, but any of the petitioner's family members, brothers, sisters, whatever. That's simply too broad. Although proper to enjoin or enter an injunction against him in relation to the petitioner, there was simply no evidence to enter an injunction preventing him from communicating with her family members. Next, kind of an interesting case. Court entered a final injunction under 740-130. For some reason, the trial court did not address time sharing. Apparently, the judge discovered that and went ahead without a hearing and entered an amended final hearing. And in that order, provided that the petitioner would have 100% of the time sharing with the minor children. There were no pleadings filed, no notice of hearing. Obviously, that's a violation of the respondent's due process rights. And that's the case of Butler versus Cabasa. Next, another interesting case on due process. And in this case, the respondent, through his attorney, filed a motion to dissolve the injunction and obtained a notice of hearing. It was on the judge's docket. Then the respondent, through his attorney, filed an amended notice of hearing for a different date. However, on the date originally set for the hearing, the respondent and his attorney showed up for the hearing. The trial court noticed that the case was not on the docket for that date, and apparently even made a comment and was concerned about whether the petitioner would have adequate notice of the hearing. Despite that, the trial court went ahead, conducted the hearing, and dissolved the injunction. Obviously, that violated the petitioner's due process rights. She was certainly entitled to be heard on whether the injunction should be dissolved. And that's the case of, I'm sure I'm mispronouncing it, Porvaznik versus Porvaznik. Next, of course, happens all the time. If you have the DV docket, someone will file a motion to modify or dissolve the injunction, assuming they state a cause of action. And by that, I mean the standard to modify or dissolve an injunction, final injunction, is a change in circumstances. As long as they set forth that, do not summarily deny the motion to modify. At least grant them a hearing. Even if you're in your office reading it and you don't think it amounts to a whole lot, at least grant a hearing. Now, if they put things in the motion such as the trial judge was nuts, he or she was asleep at the wheel, that's not alleging a change in circumstances. So in my opinion, you could summarily deny that one. But generally, there'll be enough there to grant a hearing. And I already mentioned this, that motion, if you want to modify or dissolve a final injunction, again, it's not a second bite of the apple. You can't tell the trial court, you were wrong the first time, I want a do-over. You need to allege and prove a change in circumstances. And again, although I'm doing this in the context of a 740-130 injunction, that would apply all types of civil orders of protection, as would the prior principle that generally grant a hearing on a motion to modify. Any of the types of civil orders of protection, that would be the standard. Next, kind of an interesting case, the case versus no. And in that case, the appellate court upheld the trial court's decision not to dissolve the final injunction, despite the fact that there were changed circumstances and the final injunction had been entered something like 15 years earlier. At the time he filed for the motion to dissolve, the respondent was incarcerated. He had been for 5 years. So, of course, he alleged I've had no contact with the petitioner for 5 years, and I'm not going to be able to have any contact with the petitioner for another 5 years because I have that much longer to go until I'm going to be released. However, the petitioner testified that during the term of the injunction, before his incarceration, there were numerous instances of violations of the injunction by the respondent. So the appellate court determined that even though there were changed circumstances and about 15 years had passed, trial court was right in not dissolving the injunction. When you're faced with dissolving an injunction, you have the changed circumstances test we talked about. The moving party needs to show that the circumstances underlying the entry of the injunction no longer exist, such that continuation of the injunction would serve no valid purpose. The person who wants to keep the injunction in effect needs to show that he or she reasonably maintains a fear of becoming the victim of domestic violence, and that's the no versus no case. Next, an interesting case of Carroll versus Go, and in that, or Gall, excuse me, and in that case, the trial court entered a final injunction and set child support. Apparently, by its own terms, the injunction expired after, I don't remember if it was a year, but let's say a year. Well, then, in a subsequent family law proceeding, there was an argument about whether what was the amount of the respondent's arrearage as set forth in the domestic violence injunction. When I say set forth, he was ordered to pay child support. Well, of course, one party took the position that when the domestic violence injunction ended, by its own terms, so did the assessment of child support. Petitioner obviously took the other point. However, the respondent is correct in that case. When the injunction ends by its own terms, the child support award ends too. There's absolutely nothing in 740-130 that requires a court to enter a child support award until such time as another court, be it divorce court, paternity court, or whatever, picks up the issue. Simply no such requirement. Next, this is per statute in a recent case of Sager versus Holgren under Chapter 740-130. It is not available. It is not a remedy for the court to award Chapter 57-105 fees. Sager versus Holgren, that's a recent case, and also, frankly, it's in the statute. I think the statute was amended in 2017 to make that explicit. However, and we'll get to it later, in the context of repeat dating and sexual violence injunctions, Chapter 57-105 fees are available, and that's a Supreme Court case that came out in January of 2018 called Hall versus Lopez. I don't have any authority for what I'm going to say, but I think by analogy, these fees may be available in stalking injunction cases under 784.0485, because I don't believe, could be wrong, but I don't believe that the stalking injunction explicitly says fees cannot be awarded, as does 741.30. Next, an interesting case, and this is a case of Youssef versus Saitoni. If you're going to enter a final injunction against a respondent, you need to have personal jurisdiction over the person. In this case, the parties were residents of Ohio. They had an altercation in Ohio. Petitioner comes to Florida with the kids and obtains an injunction, which ultimately became a final injunction against the respondent. The trial court based its exercise of personal jurisdiction with basically 2 or 3 grounds. Number one, that the respondent has family in Florida. Number 2, that the petitioner and the kids had came to Florida in the past. And lastly, when the kids and the wife, petitioner, would come to Florida in the past, the respondent would come down to Florida and visit the children. Well, those things are not elements of exercising personal jurisdiction over a respondent under the long-arm statute 48-193, which has a laundry list of things that a respondent can do that would, being a non-resident respondent, that would allow a Florida court to exercise jurisdiction, over personal jurisdiction over that person. Those things the trial court mentioned and I mentioned are simply not encompassed within 48-193. Also, apparently, the trial court said that there's a safety exception under 48-193. In essence, so if necessary to protect the petitioner, court can go ahead and enter a final injunction, 48-193 notwithstanding. Trial court was reversed on that. You need personal jurisdiction. Again, that's Youssef versus Saitoni. And that's kind of an interesting case, Faddis versus Luddy. And in that case, the petitioner filed her petition, and she did set forth with specificity one incident in particular. However, she alleged in a general sense about some prior problems that she had with the respondent. For example, she alleged generally that the respondent had assaulted her numerous times, had pushed her against the walls before, and had pushed her on the floor. She testified to those things over objection of the respondent's attorney. He argued that these were not alleged, these other incidents, not the one with specificity, but the other incidents were not alleged sufficiently in the petition to meet due process requirements. However, the trial court allowed her to testify about these incidents, and trial court was affirmed on appeal. I think what happened was she had checked off some of these boxes on the standard petition for injunction and did not write a narrative. She had the narrative on the one, but not on the general incidents that she referred to. Trial court said that was sufficient. Next, and we know this under I alluded to it before, under 740-130, if you're going to enter a final injunction, number one, petitioner has been the victim of domestic violence. Number two, he or she has a reasonable fear that he or she is in imminent danger of domestic violence. The Faddis versus Luddy case discusses that too. Now, in your material, I want you to take a look at two different cases. First, the case of Leo versus Rodriguez and the Zarudny versus Zarudny case. And in those two cases, the first two cases, the trial court determined that the that the petitioner at a minimum had a reasonable fear that she was in imminent danger of domestic violence. I'll mention a couple of facts of the Leo case. In the Leo case, the guy was a control freak. She testified that when they were together, he would not let her work. He would control where she went, control the money, that kind of thing. When he, quote, allowed her to work, if she were 5 minutes late, he would accuse her of being somewhere she shouldn't be, being with somebody she shouldn't be with. She did allege that there was some actual unwanted physical contact before. And what led up to the filing of the injunction, the immediate precipitating event, they were with their child together, and the petitioner asked the respondent to carry the child's book bag because it was heavy. He wouldn't do it. Then he ran up to her, used profanity, said, you don't know who the blank you're dealing with. Your parents are going to be crying. I'm going to destroy your life, that sort of thing. Appellate court said this lady, at a minimum, she has a reasonable fear of being in imminent danger of domestic violence. Zarudny, same kind of thing. However, if you go to the case of Douglas v. Douglas, that's a case where the court determined that the petitioner did not have a reasonable cause to believe she was in imminent danger of domestic violence. And in that case, what the respondent allegedly did was he drove to where the petitioner worked, waited in his car, then when she came out of work with her co-workers, he sped off. Another time, he was at the same bar she was at for St. Patrick's Day. He didn't even talk to her on that day. Another time, he locked her out of the bedroom at home and wouldn't talk to her. Another time, he was at a shopping center she was at. And lastly, he confronted her about apparently not wearing her wedding ring and why she missed one of the child's activities. Apparently, he was close to her face and was yelling at her, but there were no threats made. And in that case, the trial court or the appellate court said that person did not have a reasonable fear of imminent danger of domestic violence. Here's your little buzzword for the day when you're looking at this topic, and it comes from Douglas. The danger feared has to be imminent, and the rationale for the fear must be objectively reasonable. That's kind of your cliche. I didn't want to read it, but it's in the Douglas case. But compare Leo Rodriguez and Zarudny on the one hand with the Douglas case. Pretty interesting. Next, you may have a companion case, maybe you have a divorce as well as a domestic violence case. If you are going to use evidence from another case, be it a divorce case, paternity case, whether you're going to use that evidence to justify entering the injunction or justify not entering the injunction, don't just allude to it. Take judicial notice of it under Chapter 90.204 of our statute and make it part of the record in the in the injunction case. Take judicial notice first. That's the case of Carrillo versus Carrillo. Next, and this happens all the time, and again, this is going to apply not only in 740-130 injunction cases, but the other civil orders of protection. You may have a guy or woman who's incarcerated. They file a motion to modify or dissolve the injunction, and they do file a request to appear telephonically. Go ahead and grant that. If the person did not put in their telephone number where they can be reached, when you grant the order or execute the order setting the hearing, go ahead and write in there. Hearing's going to be on this date and time. It is the respondent's responsibility, though, to provide to the clerk before the hearing a phone number where he or she can be reached. Next, if you're like me and you have the DV docket in your jurisdiction, or you're the duty judge and you're faced with a new petition, again, this applies across the board, all types. If you are going to deny the injunction, in other words, you're not going to enter attempt, you're not even going to set a hearing, you're just going to outright deny it. Put in writing your reasons for denying the injunction. I get this a lot, and probably more often than not, in the case of repeat violence injunctions. And very often I'll see one act of violence as defined by statute. So when I deny it, that's what I put in my paperwork. Petition only alleges one act of violence, not sufficient under the statute. So don't just blow it off. You got to put in writing why you, or should put in writing why you're denying it. Next, the case of Gonzalez versus Baez. If a trial court makes a decision on a factual matter, it is not the appellate court's provision or area to second guess credibility of witnesses. And that's exactly what happened in the Gonzalez-Baez case. The respondent appealed the injunction, final injunction, but his argument came down to basically, why did you believe her and her witnesses over me and my witnesses? Well, that, of course, is exactly what trial courts do all the time. And that is not something an appellate court is supposed to overturn. Next, kind of an interesting case, and this is the case of Newsom v. Newsom. What had happened at that case, petitioner shows up for the hearing, the respondent's attorney showed up for the hearing, told the trial court he didn't know where the respondent was, asked for a short continuance, trial court denied the continuance, then simply asked the petitioner if she wanted the injunction. Lady says, sure, I'll take the injunction. And the court went ahead and entered the injunction with no other evidence put forward. Trial court was overturned on appeal. Number one, you got to have an evidentiary basis for the injunction. So if the court was going to go ahead and not grant the continuance, the petitioner still needed to testify about what happened that caused her to file and why she wants a final injunction. Simply saying, sure, I want it, that's not enough. But that's what happened in the Newsom case. Next, an interesting case, and this is the case of Smith versus Daniel. In this case, initially, the state of Kentucky entered a final injunction for protection for the wife, and in that order, provided that the respondent is to have no contact with the kids and had to remain 500 feet away from the kids. Then the parties were down here, and the state of Florida entered a final judgment of dissolution of marriage, and in the final judgment, put in that the respondent would have supervised parenting time. So you have a conflict between the foreign domestic violence injunction and then the final injunction of divorce entered in Florida. Trial court simply made, in the divorce case, apparently made only passing reference to the Kentucky order of protection, even though that order of protection apparently was replete with evidence of domestic violence committed by the respondent upon the petitioner. Trial court simply glossed over that. Ultimately, the case was remanded to the trial court to make findings of fact under Chapter 6130, as well as the order, Kentucky Order of Protection, which was entitled to full faith and credit. Next, we're going to turn to stalking, the bane of our existence as trial judges, because remember, if somebody has a problem with somebody, if nothing else fits, you can claim that they're stalking. I don't want to read this, but here's basically the definition of stalking. Willful, repeated, and malicious following, harassing, or cyber stalking of another individual. The statute and these definitions are in 784.0485. 0485 is the cause of action. We love definitions. Harassment, course of conduct directed at a specific person, causing substantial emotional distress and serving no legitimate purpose. Course of conduct, going further, is to engage in a series of acts over time, evidencing a continuity of purpose. It does not include constitutionally protected activities. The next case I want to talk about is in materials called O'Neill versus Goodwin. And in that case, the parties had been in a relationship, they broke up. After they broke up, the respondent apparently went to film school. Thinks he's the next Steven Spielberg. I don't know, but he goes to film school and apparently graduates. He begins texting the petitioner, telling her that he was going to be making a documentary film about her. He had access to some Instagram photos of her. Don't know what that's all about, but he had access to those photos, and he was letting her know he was going to make a documentary film about her that would feature her and not in a flattering light. Appellate court said that that is not stalking because, remember, next principle, contact is going to be considered legitimate if there's a reason for the contact by the respondent to the petitioner other than to harass the petitioner. And in this case, the appellate court said there was legitimate contact. The respondent was reaching out to her to let her know that she was going to be appearing in his next documentary film. And that's the case of O'Neill versus Goodwin. Next, and this is the case of David versus Scheck. In that case, what happened was the respondent knocked on the door of the petitioner, left a note, and left a check. That was it. Knocked on the door, left a note, left the check. Petitioner sought and obtained a stalking injunction. Appellate court said, not so fast. The conduct of the respondent in that case is not going to cause a reasonable person substantial emotional distress. And when you're talking about substantial emotional distress, that is to be judged by a reasonable person standard. We simply cannot get into the head of every petitioner. And that's the case of David versus Scheck. Next, an interesting case, and take a look at it because it has a great outline of stalking and some historical perspectives. And that's the case of Pickett versus Copeland. And in that case, it makes it clear that although stalking requires multiple acts, it only takes one incident of stalking to be able to obtain a stalking injunction under Chapter 784.0485. But do read Pickett versus Copeland. It does have some good discussion. I think the conflict, if you read some of the earlier cases, and we'll get to it more later, we have a cause of action under repeat violence, 784.046. And violence for purposes of that statute can be considered stalking. But if you operate under that statute, you have to have two acts of violence. And every act of stalking requires multiple acts. So some of the other cases that are brought under the guise of stalking, but under the repeat violence statute, talk about 4 or more incidents of stalking. But take a look at Pickett versus Copeland. It's really a good case for laying it all out. Next case, an injunction should never be broader than is necessary to protect the petitioner. And in the next case, the trial court went ahead and entered an injunction that enjoined the petitioner from lingering in his driveway. The problem with that, number one, it's too broad. More specifically, it could enjoin conduct that is perfectly legal as well as conduct that could constitute stalking. He could be out and pressure washing his driveway. And as anybody knows, if he was pressure washing his driveway, he's going to be out there for quite some time. So it was simply too broad, and that's the Smith versus Weicker case. Injunction should never be broader than necessary to protect the petitioner. Next, the case where the trial court or the judge that did the intake did not even grant a hearing. Trial court was overturned on appeal and said that petitioner was at a minimum entitled to a hearing. And in that case, what had happened, this is the case of Five versus Bennett. In this case, the parties had been dating. They lived together. They had been dating. The petitioner owned a company, respondent worked for that company. They broke up. Big surprise, he loses his job with the petitioner's company. Thereafter, he goes ahead and engages in a course of conduct to harass the petitioner. He began making harassing phone calls to her as well as her employees. He would show up at job sites. He would make threatening phone calls. In fact, he was arrested and charged with making harassing phone calls to the petitioner. He pled out to it and agreed as part of the terms of his probation or terms of his probation in a criminal case that he would cooperate with the petitioner in obtaining a stalking injunction, a final injunction. Under those facts, the appellate court said, look, at a minimum, this lady's entitled to a hearing. And that's the case of Five versus Bennett. Next, an interesting case. This is the case of Scott versus Blum. And in that case, the men were members of the same organization. The respondent began sending out emails not to the petitioner, but about the petitioner, and he was sending these emails out to other members of the organization. And these emails contain derogatory information about the petitioner's family, former partners and current partners of the petitioner. The only reason the petitioner even knew about these things was because, number one, people showed it to him. I mean, other members of the organization would get them and would show him, and also he received phone calls from other parties. They were never sent to him directly. Ultimately, the appellate court said, when things are put on a social media platform, when comments are made on an electronic medium to be read by others, to be read by the public in general, they are not directed to a specific person and simply cannot be stalking, or in this particular case, cyber stalking. That's the case of Scott versus Blum. It's not in the materials because it's about 3 years old now, but there was a case in 2015 called Horowitz v. Horowitz. It deals with Facebook posts and has a very good discussion about posting material on Facebook for all the world to see, even if they're derogatory. But read the Scott versus Blum case and the Horowitz v. Horowitz, because the communications were not directed to the petitioner, although they were about the petitioner. Kind of the same thing we talked about a little bit. Next case, an injunction was simply too broad. It enjoined the petitioner from not only communicating to the petitioner, I mean, that's easy, that's what it's all about, but it also enjoined the respondent from communicating about the petitioner. This is simply too broad. It violates the First Amendment, even if the communication about the petitioner is defamatory or offensive. What can happen in that case, of course, the respondent could be setting himself up for a defamation lawsuit, but that's a different thing. Simply cannot say, as part of an injunction, Mr. Respondent, you can not only have communication with the petitioner, or you can't do that, but you can also not disseminate information about the petitioner. Simply too broad. Next, kind of an interesting case, and it's a little quirky. There was a stalking injunction petition filed, final hearing, petitioner attends, respondent doesn't attend, albeit served. He doesn't attend, court enters a final injunction. Respondent thereafter files a motion for relief from judgment and alleges that he had a very low IQ and he really didn't understand the summons or the paperwork. He didn't really understand the petition, and therefore that's why he didn't show up. Appellate court said that with his low IQ, he actually stated a cause of excusable neglect for not showing up to the hearing, and the trial court should grant a hearing on the motion for relief from judgment under 1.540. Now it'd be under the Florida Family Law Rules of Procedure, 12.540. It seems kind of generous to the respondent because he was served and yet he didn't show up. And that's the case of Richards versus Crowder. Next, an interesting case called Rollerson versus Font. There were two attorneys that really at the minimum didn't like each other, and they were adversaries in a number of lawsuits. Well, the respondent alleged he did the following things. Number one, he would say things to her like, I'm going to destroy your career. I'm going to do whatever it takes for you to lose your license. He allegedly made sexual advances to her. He would say within earshot of her, he would ask other attorneys in earshot of her if they were having sexual relations with her. He told her he was having her followed by the use of drones. And lastly, he would have her served with subpoenas to require her, as well as some of her clients, to attend court hearings that had absolutely nothing to do with her. Ultimately, the appellate court said the core allegations simply, in the court's opinion, did not amount to harassment by the respondent of the petitioner under the stalking violence injunction, and that the allegations of the petitioner were better addressed in a Florida bar disciplinary proceeding. I don't know if that ever got pursued, but no stalking injunction. Next, and of course, as trial judges, you know this happens all the time. General relationship problems that you have between, in this case, I'm going to talk about neighbors, is simply not what the stalking injunction is really, or injunction case, the statute is really designed to protect. And this is the case, if you look at the first case, it's the case of Klempel versus Gagliano. And in that case, the parties were living in the same condominium unit. Petitioner claimed first that he was being followed by the respondent. Well, the evidence in that case was that by following was that the petitioner's wife would be sitting in her car waiting for him to come down, waiting for the petitioner to come down, and the respondent was also waiting, quote, waiting for the petitioner down in his car. So they're like the wife of the petitioner sitting in their car and the respondent is sitting in his car. That simply can't be following, given the fact they live in the same complex. It's simply it's not specific enough, it's too general. Next, there were allegations such as the respondent called the petitioner a wife beater, threatened to beat him up, got into an argument over condominium issues with the petitioner's wife. Respondent was alleged to have thrown some kind of chemical on the petitioner's car, which, presumably ruined the paint job. There was no evidence, in fact, that the respondent did any of those things. Appellate court ultimately said, look, this is not a victim stalker situation. It's two neighbors that don't get along, and it's basically a tit for tat situation. Stalking injunction not going to be applied in that case. Next case, kind of the same principle. This is the case of Paulson versus Rankart. The parties were neighbors. Problem started out, lady had a night light. One neighbor, the lady had a night light on outside her home. Respondent went over there, asked her to turn it off because it was shining in his house. She did that, then eventually turned it back on. Then he came back over another time. He was mad, asked her to put something around the light so it would not shine in his house. Then what happened, he started making complaints to the code authorities about the light, complained to code authority parties or personnel that her dogs were barking all the time. Ultimately, she claimed that apparently they live near the ocean, and she said she would sunbathe on one deck outside of her home. And the respondent, despite having a nice huge deck that overlooked the ocean that he could sit on, he would sit on the small deck and he could stare at her while she was sunbathing, and I guess that creeped her out. Appellate court said no stalking injunction. Appellate court said that this was not malicious conduct by the respondent directed to the petitioner, and did not believe that what the respondent did would cause a reasonable person substantial emotional distress. And that's the case of Paulson versus Rankart. Next, an interesting case. It was brought under 740-130, but really operating under stalking, which again is a definition of violence. This was a case where a young woman brought a stalking or a 740-130 action against her parents, and she claimed the following against her parents. She had some psychological issues. She had claimed that her parents went to her doctor's office and created a scene, threatened litigation from a prior Baker Act proceeding. The parents allegedly had made a number of phone calls to the petitioner and also had contacted the petitioner's friends to try to find out about the petitioner, because there was no question the girl had some kind of pretty serious psychological issues. So the parents were rightfully concerned. But bottom line, appellate court said, look, even if they went to the doctor's office and created a scene, said, you people are going to an eternal damnation, threatened lawsuits, and even if they did, even if the parents did make phone calls to the petitioner, there were no threats in these phone calls. It was not malicious conduct. Basically, and here's your little saying, the parents' conduct in the appellate court amounted to uncivil conduct that maybe caused annoyance to the petitioner, but it's simply not the type of conduct that's going to justify the entry of a stalking injunction. And that's the case of Wills versus Jones. Next, another injunction. It was too broad. This is the case of Givens v. Holmes. Parties were neighbors. Court entered a final injunction that prohibited the respondent from coming within 500 feet of the petitioner's home. Again, very standard. However, the respondent actually lived only 90 feet away from the petitioner. So the trial court needed to revisit it and reduce the buffer zone, because otherwise the respondent could be deprived of the lawful use of his property. And getting these neighbor cases that are within 500 feet of each other, they're not uncommon. I get a lot of them. Next, another case simply too broad. This is the case of Neptune versus Lanoon. And in that case, again, the respondent was enjoined from posting any material about the petitioner on the internet. Too broad, violates First Amendment rights of the respondent. Again, we're not talking about enjoining the respondent from communicating with the petitioner. That's easy. But this was saying you could not post any information about the petitioner on the internet. That is simply too broad. Next, the man who gets the Rocket Scientist of the Year award. The parties were ex-spouses, but they lived near one another. This is the case of Robertson v. Robertson. On 3 consecutive nights, uninvited, the respondent went over to his ex-wife's house, had a flashlight on him, and flashed the light into the woman's home. Then, to show how brilliant he was, he went ahead and emailed her, admitting to her that he did that. And the appellate court said this clearly meets its perfect case of meeting a statutory definition of stalking: willful, repeated, malicious harassment of the petitioner. That's Robertson v. Robertson. Next, the case, and I already really talked about it, the case of Klemple versus Gagliano. Again, you get this all the time as a trial judge. You get these stalking injunctions between neighbors. His dog's going to the bathroom on my lawn. My dog's going to the bathroom on his lawn. The kids throw the football on the lawn. They rev their kids. The teenage boys are revving their engines in their driveway, playing music loud, things like that. And it may be expedient as a trial judge. You could easily think to yourself, man, I'd like to enter the injunction just so maybe these people would leave each other alone and frankly leave us alone. You can't do that. These stalking injunctions are not designed to keep the peace between neighbors. And I will tell you, if you read the case law, it is very, very, very rare that you are going to find a stalking injunction that is upheld on appeal between neighbors for this very reason. Next, kind of an interesting case, and this is the case of Ceylon versus Grant. This case, the parties apparently had a relationship. They broke up. The respondent had sent to the petitioner something like 200 text messages to her. Well, the petitioner goes ahead, seeks and obtains a stalking injunction. At the hearing, the respondent wanted to introduce these text messages into evidence to show the court that he had a legitimate reason for contacting the petitioner. And that reason was out of his concern that she had relapsed into substance abuse. The trial court said, no, you can't introduce these text messages. Injunction is entered. Appellate court said due process violation because the text messages should have been allowed into evidence because they may have shown a legitimate purpose for the contact. Also, in this case, this is Ceylon versus Grant. The respondent was not allowed to call a witness to testify on his behalf. Next, another case where there needs to be an evidentiary basis for the entry of the injunction. This is the case of Burns versus Bacharach. And in this case, parties go to a hearing. Respondent tells the petitioner's attorney, sure, I won't contact her. But he did not stipulate to doing things that could constitute stalking under the statute, nor did he stipulate explicitly to the entry of the injunction. Court went ahead and entered a stalking injunction. Respondent then filed a motion for rehearing, which was denied. Ultimately, appellate court reversed trial court and said you have to have a sufficient evidentiary basis for the entry of the stalking injunction. And the respondent simply saying, sure, I'll stay away from her. That is simply not enough. Next, remember, any stalking injunction needs to be proven by competent substantial evidence. In the next case, and this is the case of Reed versus Saunders, the petitioner claimed that she had numerous emails and numerous texts sent to her by the respondent. However, the record showed, number one, that these texts and emails were not introduced into evidence. Going further, the evidence showed, or record showed, that these texts and emails were not even shown to the trial court. Therefore, the trial court, not seeing the text, would not know, number one, was there a legitimate reason for the contact other than to harass the petitioner? If so, can't be stalking. And secondly, would these texts or emails cause a reasonable person substantial emotional distress? Injunction was overturned. That's the case of Reed versus Saunders, because there's simply not competent substantial evidence that stalking had occurred. Trial court needed to see that. Next, kind of an interesting cases, kind of similar cases. The harassment needs to be directed to a particular person. In the next case, there was a man, he had a wife, but he also had a mistress. Well, in that case, what happened was the mistress would come over to the husband's house, and of course, the wife was there too, and she would come over repeatedly and argue with the husband. Big surprise, the wife didn't like that. The wife then sought and obtained a stalking injunction against the mistress based on her coming to the home. Appellate court reversed. The mistress coming over to the house, arguing with the husband, was not directed to the wife. Therefore, she, the wife, was not entitled to a stalking injunction. Next, in another case, and that the case is Dixon v. Sermon. Another similar case is the next case, Ashford Cooper versus Ruff. Another case where we have a husband has a wife and a girlfriend. And in this case, the wife would telephone the mistress repeatedly looking for her husband. Husband wasn't home, not at work, but boom, she deduced in her mind, husband must be over at the mistress's house. So wife starts calling the mistress to try to get in contact with the husband. Mistress, I guess, got bothered, got annoyed, whatever, seeks and obtains a stalking injunction. Again, that's reversed. In this case, appellate court said these phone calls to the mistress would not cause a reasonable person substantial emotional distress. Next, repeat violence. Under repeat violence statute 784.046, for repeat violence injunction, you have to have two or more acts of violence, one of which has occurred within the last 6 months, directed at the petitioner or an immediate family member of the petitioner. First case, and violence is defined as under 784.046 as assault, aggravated assault, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any other criminal offense resulting in physical injury or death. And in the next case, you have a case of Toma versus O'Neill, not Thomas, Toma versus O'Neill. The petitioner was a lady who worked at an abortion clinic. The respondent was an individual who stood outside of the clinic and would protest. Well, when the lady would go and come to work, the respondent would harass her. Another time he followed her from the clinic to where she worked. Another time he was seen in the neighborhood where she was driving by her house. And another time he was seen in the complex where she lived passing out flyers. The flyers had the picture of the petitioner on them, and at the bottom it said something like, please help this woman stop killing babies. In any event, appellate court said this lady proved her case. She was entitled to a repeat violence injunction, even though it was under stalking. Because remember, stalking is a definition of violence for purposes of repeat violence. Kind of an interesting case. Next, of course, we already talked about it. You got to have two acts of violence. And you take a look at the case of Tash versus Rogers. In that case, there was one battery. There was no doubt about that. The other incidents that the respondent allegedly did was, number one, approached the party's child and said, hey, kid, you're all messed up because of your parents. Didn't threaten the kid, didn't touch the kid. That's not an assault. There's no battery. Another time he approached the petitioner, said under his breath, I'm going to kill you. Didn't brandish any weapon. Anything like that, took no overt action to accomplish that. Again, that's not an assault. Long and short of it was, respondent did not commit two acts of violence, or at least petitioner could not show it, only showed the one, that being battery. Therefore, a repeat violence injunction fails. That's Tash versus Rogers. This is kind of an interesting case. It's just a general statement. This is a case when you read this, if you're a trial judge and you have your courtroom full of people and you have a bunch of people out in the hallway and you're worried about your docket, Due process does require that we allow both sides a reasonable opportunity to prove or disprove the allegations of the complaint, allow testimony of pertinent pertinent non-cumulative witnesses, allowing direct and cross-examination. When you're running a busy docket, that can be disconcerting to you, but that is actually what you need to do. Maybe the answer is you set a special hearing time when your docket has more time. But due process does require that, and that's the case of Sneed versus Ansley. Already talked about this. Just you get a motion from an incarcerated person, give you a phone number, they want to appear telephonically, let them do it. Next, the case where clearly the injunction should have been entered. This is the case of Austin versus Eshkamendi. I'm sure I mispronounced that. He didn't even attend the hearing, by the way, but she testified on 2 separate occasions. He had choked her. Then there had been repeated phone calls after that of threatening her. He had followed her and her co-workers. Another time he went to her work, waited outside her work, blocked in her car, wouldn't let her leave, threatened to kill her. Clearly, appellate court said this lady was entitled not only to a hearing, but she was entitled to the injunction. He banged on the doors of her house. Besides choking her twice, which that in and of itself is sufficient, he did all these other things. Clearly, she met the burden. That's Austin versus Enchimentia. Next, an interesting case. This is the case of Kriebel versus Pedrahadra. I already touched on it. Repeat violence requires 2 incidents of violence. Stalking can be a violence. And in this case, there was a battery without doubt. However, the petitioner was only able to establish 1 incident where the respondent followed the petitioner. 1 time of following, just like 1 time of harassment, is not sufficient for stalking. So in this case, the injunction was denied or should not have been entered because there was only one act of following, therefore no stalking, therefore no second act of violence. Already talked about this. This is the case of Hall versus Lopez. 57-105 fees are available in repeat dating and sexual violence injunctions. Next, the case of Molina versus Valenzuela. And in that case, during the appeal, the injunction expired by its own terms. So naturally, you would think that the case was moot, therefore we're not going to address it. And as a general rule, appellate courts or courts are not going to address cases that are moot. In the context of 740-130 domestic violence injunctions, though, an exception to the mootness doctrine is when there are collateral consequences that can flow from a from a case, such as in a domestic violence case, not being able to possess a firearm. That's a collateral consequence from the injunction. So in a 740-130 action, courts will address the injunction even if it is expired and even though you would think it is moot. This is a repeat violence case, not the same thing. Case was moot. Appellate court dismissed the appeal. That's Molina versus Valenzuela. Next, dating violence, kind of interesting. For dating violence, you have to have the following. A dating relationship has to be within the last 6 months. The relationship needs to be characterized by the expectation of sexual involvement or affection, and it basically has to be a continuous relationship. It can't be, isolated, go out on, a date every 4 weeks. That's not what we're talking about. Now, assuming you meet that, here's the standard. You got to be the victim of dating violence and have reasonable cause to you're in imminent danger of becoming the victim of another act of dating violence. Or you have to have reasonable cause to believe you're in imminent danger of becoming a victim of dating violence. That basically means, in a nutshell, in a nice way of putting it, you can be the victim of dating violence unless you can establish that you have a reasonable fear of becoming the victim of another act of dating violence. You don't get your injunction. Kind of a weird statute. And that's the case of Nulia versus Stope. The woman said, look, he hit me once, he'll hit me again. Simply not sufficient. In that case, there had been, after the dating violence incident, there were no further attempts to contact the petitioner, nothing else, no inappropriate communication, interaction, nothing. Petitioner simply couldn't meet the second prong, even though she had been the victim of dating violence. Kind of a weird statute. Already talked about that. That's not enough. He hit me once. He'll hit me again. Next, kind of an interesting case, and this is the case of Floyd Walker versus Gray. This involved 14-year-old kids that were in middle school that the petitioner testified they were going out. The reality of it was they didn't go anywhere without their parents, but they hung out in school together. So they probably walked between classes and that kind of thing. They couldn't drive and they didn't go anywhere without their parents. In that case, the respondent was claiming that the petitioner did not have a relationship contemplated by the statute. We were as kids, at school, not a dating situation as contemplated by the statute. Parties broke up. Then in school, the respondent began to threaten the petitioner that he was going to kill her. He did that numerous times. Ultimately, he grabbed her wrists. Appellate court said that person has the relationship contemplated by the statute was met, even though they were 14 years old, presumably not engaging in sexual activity. In any event, that relationship was satisfactory. Next, the cases, you get this all the time. This is Speaker versus Roden and dating violence or any other type of injunction. You may have a companion criminal case. Maybe the respondent is afraid to testify in your case, the civil case, because of the pending criminal case. Everything he says could be used against him. If he asks for a continuance or a stay of the civil proceeding, you don't have to grant it. You can, but you don't have to. That's Spiegel versus Roden. Sexual violence injunction, I'm only going to touch on it. Basically, you need to cooperate with law enforcement, report it and cooperate, or the respondent who committed it has already been sentenced or to his term of imprisonment, which has expired or is going to expire within 90 days of the filing of the petition. Take a look at a couple of cases, TB versus RB and Keller versus Ramsire. Those basically stand for the proposition that if the injunction is sought by a parent on behalf of a child against a parent, step-parent, or legal guardian, you got to have more than the child's word. You need to be an eyewitness to the events, you have to have affidavits from eyewitnesses, or you have to have physical evidence. All right, folks, that really concludes the webinar. If you have any further questions, email me at tineman@circuit5.org, and I'd be happy to answer any questions. Thank you.